Maybe. Well, on account of my personal inconvenience, well, may I pray, item, my lord, 34 and 35 may be taken up, my lord, after reopening, any day after reopening, my lord. 33 and 34, my lord, not 34.
33, 34.
33, 34.
This, okay. What is this IA for?
My lord, IA for, my lord, condonation of delay.
How much did it delay?
My lord, delay approximately, my lord, 4,000 days, my lord.
Okay, then we adjourn it.
My lord.
33, 34. On the, both sides are represented on the prayer made by Mr. S.K. Talukdar and counsel for the applicant. List on, list after ensuing,
My lord, after the vacation, my
after
lord.
ensuing winter vacation.
My lord, God bless you.
Please, please, Lordship. Lordship, I have to mention item number 28 of today's list also.
28.
28. So in this matter, my lord, the service upon the private respondent is complete. So may I pray that this matter will be taken up after the Bihu vacations in the admission column, my lords.
Service is complete.
Service is complete, my lord. There is an order of the Lavazima Court, 49, saying that the service is complete.
At the mentioned stage, Mr. S. Viswakarma and counsel for the petitioner submits that the case is ready as regards service in view of the order passed by the Lavazima court. Mr. P. Sharma and the government advocate is present. List after the ensuing winter vacation.
Deeply, my lord.
May I please, your lordship? Lordship, item number 18, admission, my lord. Admission 18, 18, my lord.
18. Yes.
Yes, my lord. My lord, I am praying for upgradation of this matter. Before writing matter, this matter listed for the last 2 occasions will not raise, my lord. Anything, before writing, at least my matter may be taken up, my lord.
We will see because
Yes, my lord.
today
Yes,
hearing,
which court convenience, my lord. Deeply obliged.
hearing would be very difficult today.
Yes, ma'am.
May I please?
Yes.
I beg to mention item number 11, my lord, admission here. Kindly take up this matter after vacation, my lord.
11.
11.
This 19 matter, please wait for some time. We'll take it up and then adjourn.
May I please, your lordship? Your lordship, I beg to mention item number 14, your lordship. Your lordship, may
14,
kindly.
1, 4.
Yes, your lordship.
You have to
Lordship,
wait. This is a 2019 matter.
Your lordship, at the time of filing this writ petition, the petitioner was an old age person, your lordship. So we could not able to call her whether she is alive or not. We need
No,
to
but
take
still,
instruction, your
it's a
lordship.
19 matter. We have to take it up and then ask for this. The matter is called. Renew the
Sure.
prayer when the matter is called.
Your lordship.
May I please? So for item number 3 is concerned, there is an order of this honorable court dated 29/5/2019 to tag with WPC number 3116/2019. It has
Let
not been
us-
tagged.
Let us have it.
Yes.
Not
May I please, lordship, I'd like to mention item number 16 of admission.
item
Number 16. Yesterday,
1-6.
yes, yesterday we have submitted our adjournment slip.
Okay, yes, yeah. Okay, both sides are represented. Advance adjournment slip is circulated for adjournment of the matter. Accordingly, matters shall adjourn today. List on, give a date after. vacation.
Deeply of.
Yes,
May it please your lordship. Lordship, I beg to mention regarding item number 32 of the supplementary list. Lordship may kindly upgrade the matter for hearing today.
32.
32,
We'll see
lordship.
because otherwise also will come to it. Okay,
May I please, Lordship? Next mention item number 13, my lord.
13 is 2019 matter. You'll have to wait till it's called. Yes,
For fresh listing, man, it's a fresh listing. It may come up tomorrow.
item,
It's for motion, man. It's listing.
motion matter.
Yes, sir.
Okay.
May I please, lordship? Listing for motion, your lordship.
Item 1 for motion.
May I please? Can you kindly see the improved order that is not Order 3/11/2018, page 37. It was moved earlier and bail was granted, and I am on bail now.
Opinion is at page.
Page 37.
You have any voter list along with your along with your mother?
No, on the father, mother, we have no father, mother, they have prepared for me. And my name first appeared in the voter 2005. Only
Any
my-
document where you are there with your mother?
Lord, I was with my mother before marriage. After marriage, I
So
am.
that's why we are asking you, any document with your mother? No.
No. Only one certificate, that is like officer certificate, that is
Which certificate?
Gao Panchayat, and that was proof,
Gaon Panchayat
my lord.
or or
Secretary?
it is,
Government. Kindly get page 50, annexes 15, page 50.
or it is
It was proof. Page 58, my lord.
58.
File.
Okay, that goes because of the state emblem.
Hmm. Hmm. See, secretary, that is the government employee, my lord, not the elected person. There is actually no other document with my father or mother. It's because after marriage and before marriage, there is no any education. School certificate, no.
But the difficulty is that when you produce witness, you don't know anything.
If my mother was,
see-
mother was there.
No, mother, there is no document to show that she is the mother. That one.
Mother,
Then you,
mother is the witness.
no, but you see, who is the mother, we don't know. Somebody comes and says that he is my daughter.
He is my daughter, he is my mother.
I'll tell you a small story. I am
understand
good
that.
in telling stories. At that time, I was a lawyer. I was, while in practice, I had gone to Golaghat. In Golaghat, a big, what do you call, court acrimony occurred with the one lawyer and the judicial magistrate. It was so loud that I was in a different court. I went there. The lawyer who was appearing looked almost similar to Mr. H. Ali, who is your colleague here. Almost similar. That's why I asked him one day whether you are practicing in Golaghat. He says, no, I'm from Kolkata. So very similar, and the fight erupted. And you know why the fight was there? This person comes and says that my affidavit has to be accepted by the, has to be signed by the magistrate. Magistrate says, I couldn't understand, I will not sign it. And the contents of the affidavit was, he is staying with me. Since he was small, he was staying with me. He is my son-in-law. And therefore, this affidavit to show that so-and-so is so-and-so. Magistrate said, I don't know. He was staying from in his house. How can he be son-in-law? I can't understand. So I told the person, I was nobody there. I was just a lawyer in a different matter. I asked the lawyer, please explain me in Assamese, what do you actually want to convey? Then he says in Assamese that the man says, "Hey, এইটো সৰুৰ পৰা মোৰ ঘৰ ডাঙৰ হৈছে, মোৰ ল'ৰাৰ নিচিনাই, তো আইন মতে মোৰে ল'ৰা." So this ain mate mure lora was made in Assamese, it was made son-in-law and the court agreement. So that is my experience with people coming and say that he's my son, he's my son-in-law. Therefore, if there's no document to connect, that's only a statement in the oral statement. But you see, you bring DW4.
Right.
DW4 that he does not know the father.
Right.
And the mother came and applied before him for a certificate and he gave that certificate.
Hajara Khatun applied and.
And he gave the certificate. So it's not with personal knowledge, notwithstanding that it has state emblem, but that connect is not there.
No, if like government certificate goes Milord, then I have no case. But only my submission of government certificate issued by the authority Milord, he is a competent person, he is a not elected, he is selected, he is appointed person by the government. So Milord, that value if you should consider that it will be Milord.
No, certificate is not by Gampura, it is by Gaon Panchayat.
Government is government Milord. Government secretary is a government appointed person Milord. And not by the president or secretary, that's the president.
Okay, today we don't want to dismiss. You fix it for hearing. Both sides are represented. As the records of the panel is received, what is inclined to issue rule returnable forthwith without requiring any steps to be taken. List the matter for hearing in the week commencing 2/2026. Someone kindly note that.
6th of January.
Week commencing 2nd of February.
February.
Item 2 with 3 for motion.
Please, your lordship. In item number 3, there is an order of this honorable court dated 29/5/2019. In the last paragraph, lordship, it was written that it was directed to list along with 3116/2019. That is not been listed, lordship.
Just a moment.
Yes. Yes, connected.
Now, please tell me, in motion, why you need support of another writ petition?
Because lordship, that was a direction of this honorable court.
See, we have studied motion matter. In 19, you made that clear, and from 19 till 25, the matters never come. It's a motion matter. You tell us how your case should be admitted.
Because
Why, you see, in opinion, for item number 3, in this item number 3,
lordship.
please see if there is any reference to this opinion of Atwar Rahman.
All of them are both, item number 2, 3 are the sons and father and son. And the Atwar Rahman is also son of item number 2.
No, those are all independent matters. In motion stage, we don't want to tag it. Because this tagging would only be required at the time of hearing.
Since the LCR has come, lordship may fix it for hearing and along with, let the WBC 3116/2019 may be listed along with. Oh, same. Yes, common LCR. LCR is also common, lordship.
So we don't know, we don't find it is a common LCR.
No, it is 2, 3.
We don't find it is a common LCR. That is the problem.
Next, hello, motion.
Both sides are represented. You are separate orders. By order dated 29/5/2019. Passed in WPC 3213 of 2019. And order dated 17/11/2019, passed in WPC 3046 of 2019. This matter is tagged with WPC 3046 of 2019. Next, while notice of motion has already been issued in WPC 3, in this writ petition, the connected WPC 3213 of 2019 is yet in motion stage. As this matter is ready for as the records are received, court is inclined to issue rule returnable forthwith without requiring any such. This is the matter for hearing. 29 January 2026. This is the second item. Issue rule returnable forthwith. Job requiring any special of the record. This is the matter for hearing on 29/1/2026. In the first case, 3213, let's say, as this is a whole pending matter, or the matter shall be taken up for hearing even if the records of WPC 3046 of 2019 is not tagged. Oh, sorry, 3116 of 2019 is not tagged. It's very clear, this, even if it is not tagged, we will take it up for hearing.
Lordship. Oblige, Lordship.
Item 4.
Yes.
Your Lordship. Lordship, TCR was called for and it has been received, it since your Lordship.
Because this case, we had to go through it.
Lordship,
The reason is your earlier submission is recorded
Lord,
that the court, the tribunal
Lordship,
failed to appreciate the evidence on record.
Lord,
So having gone through it, we found that tribunal has discussed the documents.
Lordship,
Exhibit 1, it says that you certificate is there of the Gaumra, but the place of residence itself is not written.
Lordship, Lordship.
Then exhibit 4, the father is suddenly missing. There's no statement in the written statement with regard to the father whose name is missing in the subsequent voters list.
Lord. In this matter, your Lordship,
Other matters, other exhibits are exhibit 2 is a bank account.
Lordship.
How do you connect yourself to your parents?
Your Lordship, the only connecting document is that your Lordship, connection is that your Lordship, I have mentioned in my written statement about my brother, your Lordship. And my brother appeared before the tribunal and he deposed that I am his sister. And my brother has also exhibited, I have also exhibited a revenue receipt, your Lordship, where my brother has paid the revenue receipt and along with him, my grandfather's name can also been seen, your Lordship.
No, but
And
then you also prove the land revenue payment receipt.
Lordship,
That is exhibit 6.
Lordship.
The other document for the land is not there.
If your Lordship, move on to Annexure 2, I am my father's name is enlisted in the voter list of 1966. His name is Imran, your Lordship.
Exhibit,
Exhibit, your Lordship. Copy of voter list, Exhibit 5,
voter list of
1966, Lordship. So my father's name is Imran and my grandfather's name is Isahak, your Lordship. As per this voter list, your Lordship.
But it's not connected. Because so far as you are concerned,
Lordship,
you only have a voter identity card.
Lordship,
You not even exhibited the what you call the any voters list.
Lordship,
Your name does not appear,
Lordship.
and evidence was recorded in 2014 or 15,
Your Lordship, 2018, your Lordship.
18.
Lordship,
2018, you were
37,
88.
38, 1980, 22.
Your
Part of,
voting right would be 21.
your Lordship, 18.
No, after 89, it will be 18.
Yes, your Lordship, and she was 18 after 89.
Hmm?
She was 18 after 89. So by 98, she was 18.
Then those voters are not there.
Yes, your Lordship.
Then
Your Lordship, since she has the electoral photo identity card, she definitely has the right to vote, your Lordship. The thing is that, your Lordship, in the proceeding, your Lordship, those voter lists were not exhibited, your Lordship. Your Lordship, that is the
okay,
lacuna.
today I am not in a good mood to dismiss it.
Lordship,
Except for hearing.
take note, Lordship, in the WS, at page
No,
27.
we saw it only because of the fact that in the motion, when the matter was taken up, this court recorded that the evidence was not discussed. Therefore, we just wanted to see how the evidence was discussed and found that it has been discussed. Today, last, is trying to, that vacation fever is there. Gets a benefit for that.
Lordship, I have just gone through the order, your lordship. Maybe the in the earlier order, your lordship, the court noted that the evidence of DW3 was not that discussed in the order. Yes.
During the date panic on the year, page 91.
Lordship.
50. I will find.
Lordship. Oblige.
Line you.
Oblige.
Why we were doing here.
Lordship.
Next, I think I will for activity.
Item 5.
May I please, your lordship? Lord, this is an expertly opinion, my lord. Lord, order date 33/2021. And my lord, the petitioner initially, my lord, appeared through his engaged counsel and obtained 3-4 dates, my lord, for filing WS. Ultimately, my lord, she could not file her WS. And in the meantime, my lord, the entire country was, my lord, locked down due to COVID-19. Accordingly, the expert order was passed. And my lord, the petitioner on 25/5/2025, she was taken into custody. And thereafter, my lord, the petitioner is before relapse. And she is, my lord, at Matia detention camp. And I have filed an IM, my lord, for bail, my lord. By yes, my lord. This would- My lord, some medical documents are annexed, my lord, here, page 13 in IA. My lord, that part, I'm sorry for that part, my lord, that to be get, and my lord, the two paras are there, my lord. 29 and 30, my lord. I'm not pressing. My lord, on last occasion, that question was arise, my lord. And my lord, I have three, 4 cases, my lord, like this one. Honestly speaking. Last occasion, my lord, one was withdrawn. That is in 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 the my lord order sheet, it is also mentioned, my lord, the court proceeding. Lord, base documents, my lord, the voter list of 1970. His father name is there, her father name is there. And my lord, no, my lord. Yeah, my lord, only her name appeared in the voter list of 2005, along with her husband, my lord. 2005, 10, 13, 18. Only the voter list. My lord, kindly have a look in page 13 of my IA. My lord, she is, my lord, at detention camp Matia, my lord. Page 30. Yes, my lord.
Next paragraph. Therefore, bail shall be made in the connected interlocutory application shall be considered on receipt of the tribunal's records. Being passed to the connected IA. Next list on 28/1/2026. In the IA, you say that so and so by filing this interlocutory from the applicant, so and so is praying for bail as she has been taken into custody on 25/5/2025 and presently lodged at Transit Camp or Matia Gwalpara since 26/5/2025. Next, therefore bail shall be considered on receipt of tribunal's records which has been called for in the connected date petition. Next paragraph. Till the next date of listening, comma, the respondents shall not deport the petitioner, namely someone so and so, alias Manora Begum, out of the country without order of the court. Next, the family members of the petitioner shall produce a certified copy of the order before the superintendent of Transit Camp Matia Gwalpara, superintendent of the in charge, Transit Camp Matia Gwalpara, to bring the order to the notice of the state authority. Next, list on 28/1/2026. Just take a short break.
Item 6 for motion. Item 6.
May I please, Your Lordship? This is a contested matter. Petitioner is declared to be post
Page.
page 87, Lordship.
Events available for protection and also for PPI.
22. Okay. Heard Mr. K. Rahman, learned counsel for the petitioner and so for the respondents. Opinion at page 87, dated 10/6/2022, passed by so and so in FT case number so and so, FT case number so and so, IMDT case number so and so. Thereby declaring the petitioner to be a foreigner of post 25/3/1970 stream. Next one. In view of the inordinate delay in selling the impugn opinion, keeping the issue of maintainability open, my issue notice returnable on fixed date. So and so. Extra copies within 2 days. The records to the following email address of the learned tribunal. The prayer for bail shall be considered on receipt of the tribunal's records. Next paragraph. In the meantime, if the petitioner, namely Ali Sheikh, is apprehended, he shall not be deported out of the country without order of the court. Next paragraph. The petitioner shall cause production of a certified copy of the order before the Superintendent of Police border, Dorong. Bring the order to the notice of the said authority. Dorong, Mongozai.
2nd of February.
Obliged.
Second, you appeal file, yeah. Next page.
Item 7 for motion.
May I please your lordship? Lordship, matter may be adjourned for today. Due to some personal difficulties, my senior left the court.
Just a moment.
His lordship.
Adjournment now, Lordship. After vacation. Please.
Item 8 for motion.
My pleasure, Lordship. Lord, impugn order is page 67. 67. 2022 opinion, my lord.
The Honorable Standing Counsel for the active matters has raised the issue of maintainability on account of delay and latches in assessing the impugn opinion accordingly, keeping the issue mentioned with the open on account of delay and access. Notice returnable on, Wednesday. Extra copies within 2 days. Of the record. Following email address. Prayer for bail shall be opposed, shall be considered on receipt of the tribunal's report. In the meantime, if the petitioner, namely Hajira Khatun, is apprehended, he shall not be deported out of the country without order of the petitioner shall cause production of a certified copy of the order before the Superintendent of Police Border, Bongaigaon. Bring
Abhaypuri,
the
my lord.
notice of the
SP Bongaigaon number 2 Abhaypuri.
list of the 2nd of February.
I'm obliged.
इसका नहीं बेटा, second February reach का, पहले वाले का. ये तो भी हुआ
or
है.
motion supplementary item 29.
Here in this case, my lord, three petitioners before your lordship. My lord. 1 and 2, they are father and son. And 3 is the wife of 1 and mother of 2. Here, my lord, 1 and 2, they are undergoing life imprisonment in connection with a criminal case. And 3, my lord, she has been detained prior to the giving opinion, my lord. This is an ex parte opinion for default of only 1 day. The record shows, my lord, there are some contradictory, my lord, statement. In one place, the order says only 1 day default, but in the opinion itself, it is said many years default. Your lordship, for a moment, kindly peruse page 199. This is the order dated 21/3/2025, passed by the tribunal. The opposite parties are absent. The engaged counsel is present. My lord. My lord. But, okay. But see, where otherwise their successor will be informed. My lord, what is page 199? 199.
Thanks for the concerns expressed.
Sorry for the inconvenience.
Yes,
Yeah, my lord. Challenge is made against an ex parte opinion. So at this stage, my lord, may I pray, my lord, the matter may be listed for motion on 6th.
where is the impugn opinion?
Imping opinion, my lord, is at page
104.
10/6/25. Yeah, at page 204. Court order says only 1 day. The earlier date, petitioner was represented by their advocate. 1 date not present.
But you said that there are 3 petitioners here.
Yes, 2, I have filed bail for 1 because she is in detention camp. And the
Who
other
is-
2, they
who
are
is taken
serving
into-
life
Who is
imprisonment.
taken into custody?
Petition number 3, she is in custody, my lord.
Name.
Misma Khatun, 24/5/25. Prior to the, my lord, rendering opinion, my lord, she was taken to detention camp. And to that effect also, she has filed a petition criminal.
No, we are asking you this because in the opinion at page 204,
Yes,
the first name is Anwar Ali, second is Misma Khatun.
yes,
She is the one taken into custody.
yes. She is, Misma is taken into custody, detention camp here.
Okay, where is, from where do you say that she was taken into custody earlier?
No, on 24/5, my lord. On 24/5/25, she was
Where,
taken.
where is that?
That I have stated because your lordship will find the 211, your lordship order. There was a repetition criminal, habeas corpus,
Page
211.
111.
And that was, my lord, accordingly disposed of, giving liberty to the petitioner to challenge the ex parte opinion.
No, but the date on which she was taken into custody, that is what we are wanting to see.
That I have stated
Where?
on instruction, my lord, she
Where,
has.
where is that?
In main petition also I have stated.
Where is that? I'm not doubting you, but I have to be sure.
Yeah, paragraph 21, page 17. He was earlier arrested in connection IMDT case, subsequently released. Thereafter again she was arrested. Because on the date of arrest, there is no opinion against her. It was subsequent, 10/6. And because of that, she had to approach this court, my lord, with habeas corpus. So far, my lord, case record itself says, I have pointed out the page 199,
We will not be able to follow something.
my lord.
You see, Ms. Verma, you have to get us information. You see what has happened here. It appears that the tribunal had first passed an order declaring the petitioners to be foreigner,
IMDT.
IMDT. Now this order was challenged and the order is at page 194.
The writ petition dismissed.
The writ petition is dismissed. Why was there a second reference?
Therefore, writ appeal. Writ appeal was preferred against the dismissal of writ petition.
Yes.
In the writ appeal, matter was remanded back.
Where is that?
Next, 197, Lordship.
197.
Is it 197?
Yes. Writ appeal order
No,
page
no, this is
141.
197 is 194 same thing.
This is another one.
141. Writ appeal of. And 142 relevant portion. 143 your lordship will find. 143 page, first paragraph, last line. Accordingly, we direct that matter will be remitted to the foreigners tribunal at Shankardar Nagar. It is made clear that the tribunal will not be bound by the finding already recorded, but will take into account the evidence on record. That was remand way.
Thereafter, what happened, my lord?
Just a moment.
Some further incident occurred in this case. Here fixing date 19th October 11.
Ms. Verma, the correctly of the issue would be this one page 142. Now see what has happened. The proceedings was decided by the IMDT. That is the first. That was challenged in a writ petition. Writ petition was dismissed. Then an appeal came,
Before
this is
the,
page 142.
yes, Lord.
Now in this writ appeal, the judgment of the single judge was also not set aside. Neither the order of the tribunal was set aside.
Just remanded back, Lordship.
Just matter was remanded back
Yes, Lordship.
with the direction that it will not be bound by the finding.
And in the meanwhile, Sarvananda Sonowal also came, Lordship.
Sarvana Sonowal
2006.
was at the time of the writ petition, what you call the,
Say,
when the tribunal decided the writ, that was already there.
Tribunal comes after tribunal order.
there's another order at page 191, Lordship, by a 3-judge order.
That I am coming. my lord.
That's what we are not following it. We come to page 144, 94,
94,
194.
yes, Lordship.
Now, prior to that, my lord, I just, if your lordship permit me, there's some subsequent development. my lord. In 143, my lord, your lordship has already gone through. The division bench, honorable division bench has fixed the matter on 19th October. Remanded back the matter fixed.
That is not the sequence. That's why I'm showing it to her. This writ appellate order
Yeah.
is of 15/9/2011.
Yes,
The judgment of the single judge is 25/5/15.
yes, Lordship.
In 2000, this 15 when
No,
it
no,
came,
why it is come, my lord, that I am explaining, my lord. So in this case, my lord, the division bench has directed the petitioners to appear on 19th October 11. On 19th October 11, my lord, your lordship will then kindly come to the page 145. The petitioner was unable to appear, but their advocate had filed an application. That was rejected. So against this order, my lord, 1910-11 order, the writ petition 1043 of 13 came up, my lord. In 104313, the prayer was to set aside the 1910 order, my lord. Your lordship will find the prayer portion at page 186.
Yes.
A. As to why writ in the nature of certiorari and such order, like nature, should not be issued, declaring the impending action and consequent order dated 1910-11. So 1910-11, rejecting the application filed by the advocate, the petition was filed. Now, your lordship is aware, my lord, there was a batch of writ petition and some issue was taken up. So all this foreigners matter was taken together. Here, full bench has directed, my lord, in page 194, 192, your lordship will find. This is a full bench order in 1043,
Yes.
page 192.
Yes.
1, 2, 3, third paragraph. The landed member Foreigners Tribunal Shankardev Nagar Hujai shall proceed with the proceeding pending before it in so far as it referred to present petitioner, but shall not render opinion unless otherwise directed. So it is directed to proceed with the case, but not to render the opinion. So thereafter, the present case registered, my lord, against the present petitioner. Now, ultimately, the writ petition number 1043 came up before the landed single judge, and by page 194 order, holding that this, without going into the, my lord, pleading, my lord, the case was the petitioner is the 1910-11 order of the tribunal. But that was not taken into consideration. The whole petitioner dismissed, holding that your lordship will find at page 196, last two line. The second writ petition is not maintainable, accordingly dismissed. It was accepted as second writ petition on the same issue. Now, my lord, after full bench judgment order, I have already referred to, after full bench order, the present case was registered as Foreigners Tribunal FT case. And that case was, my lord, deferred on many occasions for furnishing of the order in WPC 1043. That was not done. The 199 order, your lordship will find, page 199. The opposite parties are absent, engaged counsel is present, order of Honorable High Court is yet to be received. Here is speaking about the final order of the writ petition, madam, 1043. Opposite part, the engaged.
What is the final order in 1043?
That I have 194, it was dismissed,
Okay,
holding that the
194
second
dismissed.
petition was not maintained.
Ah.
So that was not communicated to the tribunal. And for that reason, my lord, the matter was adjourned on various occasions. And ultimately that on 21/3/25, the engaged counsel submitted that the opposite parties are not able to provide the said order because the, my lord, 1 and 2, they are, since 17, they are in custody. They are in jail. Let the order be tracked down through online. Now the tribunal has summarily taken to take the order from online. Now next order. On 13/5/25, page 201. The opposite parties are absent. The engaged counsel is also absent. Order of the High Court is obtained online. It reveals that second writ petition number such and such is finally dismissed on such and such. As such, there is no bar for this tribunal to pass the final order. That the opposite parties are absent for many years in this reference. The reference shall be decided ex parte on the next date. Next date fixed, opinion on 10/6. In between, your lordship, this earlier order, engaged counsel represented the petitioner. But here the next order said for many years they are absent. So on 10/6, ultimately ex parte opinion was rendered, that is at page 204 and 205 it is held that thereafter review petition was filed, page 207, that was also dismissed. Page 207. And in the meantime, my lord, because prior to 10/6/2025, the impugn of opinion, and the petitioner was taken to detention camp prior to that, 24/5. So she approached this court, my lord, with writ petition criminal 53 of 25. That page 201, 210.
Okay. Ms. Verma, then we give bail to the petitioner, taken into custody before that. And so far as 1 and 2 is concerned, already in custody in the criminal case.
Their bail petition is also not filed. That's all it is.
But your statement, the writ petition is not very clear. Had we not asked you this question, it would not have been very clear from your writ petition, the sequence of events.
Because
Right.
my lord, in fact, whatever I can explain, my lord, the original person who are
Yes.
taking stay,
Your,
they are in custody.
your storytelling is good, but not in writing.
But the proper sequence, my lord, only after going through record, I have collected all these things.
Mr. A.I. Uddin, learned counsel for the petitioners, and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 29, ex parte opinion dated 29/8/2025, passed by the
10/6.
10th, that is which page?
104, 204.
10/6/2025, passed by page 204, passed by so and so in FT case number so and so and case so and so, thereby declaring the petitioner to be a petitioners to be foreigners who have entered into the state after 25/3/1971. Next, the learned counsel for the petitioners has submitted that there are 3 writ petitioners in this case, out of which the petitioner number 1 and 2 are serving sentence in connection with a criminal proceeding. So it is further submitted that insofar as the petitioner number 3 is concerned, namely, Misma, M-I-S-M-A, Misma Khatun, K-H-A-T-W-N, as per the statement made in paragraph 21 of the writ petition, she was taken into custody on 24/5/2025, whereas the impugn opinion was rendered on 10/6/2025. Next paragraph. You should notice returnable in 4 weeks. Extra copies within 2 days. Call for the record, the following email address of the learned tribunal. Next. List on so and so along with the tribunal's records. And there is an IA. But so. By filing this interlocutory application, the applicant who is the petitioner number 3 in the connected information is praying for bail. First off, it is, next para, it is projected that the ex parte opinion was pronounced on 10/6/2025, which is essentially the connected writ petition, but the applicant was taken into custody on 24/5/2025. And thereafter, the ex parte opinion was rendered. Full stop. It is also projected that the petitioner number 3 is aged 70 years. Next paragraph. Although the standing counsel for the FT and border matters has opposed the prayer for bail, but considering the projection made in the connected writ petition, and also taken into account that the petitioner projects herself to be 70 years of age and was arrested on 24/5/2025 prior to the rendering of the opinion dated 10/6/2025. Now the court is inclined to grant bail to the applicant, namely so and so, by providing as follows. There are 3 conditions. Take it from my secretary. Next para. As a condition of bail, the petitioner is directed not to leave the jurisdiction of Superintendent of Police, Border, Nagaon, without prior written intimation to the said authority.
Ujai.
Is it Hujai?
Ujai.
Okay, make it Hujai. The original reference was from Nagaon.
Original reference from Magadha.
Now it is Hujai.
Now it is. She is now at Kukraja detention there.
Detention center at,
Kukraja.
just say when we have said this, taken into custody on 24/5/2025 and is presently lodged at the holding area, comma,
Kukraja only point.
holding area 7th AP Battalion, comma, Saraikula, comma, Kokrajhar. Kokrajhar.
Man.
Sarai, CHARAI, KH वाले हैं, Saraikula, Kokrajhar. This application stands disposed of. The condition that it will not leave the jurisdiction of Supreme Police without prior intimation in writing to this report, then disposed of.
I am obliged.
Who weeks will put?
Supplementary item RT for motion.
Check the records also. We not receive the copies.
We'll take it after some time. Suleiman was here.
I will take it. 17.
We'll, after some time. He's been taken into custody for deportation, but seeking, making a prayer for bail. You don't have a copy of the, just give a copy.
Item 30. Item 30. Copy.
Upgraded item 25 with 26.
Twenty-five, 26. My birthday, 25, 26.
Ms. Verma, in this case, although the petitioner's the applicant is not represented, here what has happened, you have a copy of the writ petition?
I have it, Lordship.
Writ petition
I
page?
have item 26 with me. गलत है बेटा ये रमजान वाली होना होगा 25 ये गलत लिखा है आइटम 25 है ना
805019. Yes. In this, one page plus or minus, you'll find it page 16 is the final order, that opinion. This is of 2019. The 19 writ petition was, the opinion was 2019, in 2019 itself, the writ petition was filed. Now, since no prayer for bail was made, no bail was granted, and now the petitioner has been taken into custody.
Yes.
We can release them because since the writ petitions are pending and they were taken into custody on 17 July 25. So more than 6 months, almost 5 months, they're already there. None gives on call to the applicant. I was so and so present for the respondents. Next paragraph. By filing this interlocutory application, is projected by the applicant, who is the son of the petitioner in WPC 8044 of 2019 and WPC 8050 of 2019. It's praying for bail for the writ petitioner, namely Ravi Ali alias Ravi 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 Ali, who is stated to have been taken into custody on 17/5/2025 pursuant to the opinion dated 13/5/2019. Sorry, 14/5/2019 passed by the Foreigners Tribunal number 3, Jonai Dhemaji, in FT case number 1188 of 2016, as well as opinion dated 13/5/2019, passed in FT case number 322 of 2016. Thus, it is posited that the father of the petitioner has been twice adjudged as a foreigner. It is also projected, next para, it is also projected that during the pendency of both the writ petitions, the father of the applicant has been arrested. Not arrested, say taken into custody, and is presently lodged at the transit camp, Matia, Gwalpara. It is further projected that the applicant had gone to the, oh, this is temporary jail, not transit camp. We don't make it transit camp, it is temporary jail. It is also projected that the petitioner had, the applicant has gone to the temporary jail, Matia Gwalpara, and has obtained the signature of the writ petitioner in the Wakalatnama, which is attested by the assistant jailer. Next para. Although the learned standing counsel for the FT and border matters has opposed the prayer for bail. But considering the fact that the opinion passed on 14/5/2019 and 13/5/2019 respectively have been assured by filing the writ petition in the year 2019 itself. And that the father of the applicant has already spent around 5 months in custody.
About I think painting in the years.
What is inclined to release the father of the petitioner, namely Mohammed Robi Ali alias Ravi Ali, on bail on the following conditions. There are 3 conditions. Take it from my secretary. Next para. As a further condition for bail, it is provided that the petitioner have now namely Mohammed Robi Ali alias Ravi Ali cannot leave the jurisdiction of the Superintendent of Police Border Dhemaji without prior written intimation to the said authority. Bail is to the satisfaction of same. This is stands disposable. Has been carried. No, there's another difficulty now, having passed the order. There are two opinions. He has been taken into custody in one. What happens to the second one? There's no application. Can you find out by, before we rise regarding the, or even later on, we'll both take a call. This arrest has been, the writ petition has been arrested in connection with which matter? There are two opinions. After two opinions, he'll be arrested in one. So if he's not arrested in connection with 8044, then this order has to be recalled. It will not help him. Try to get it. During lunchtime, if anybody can inform Mr. PJ Saikia, do better. You can. I thought actually we change the model of
40 My lord. My lord. Both the application. I do not know, my lord. Right now I came to know, my lord, about this. I will file another application, my lord. And your lordship, if lordship praises, my lord, the present I may be considered, my lord, then.
Other will remain.
My lord. Yes, my lord. My lord. I will file immediately, my lord. Sometime maybe alone. My lord. Yes, my lord. Yes. I have already given, my lord. My lord. Sometime maybe alone. $25 and 10. $25 and 26. My lord. In 25, I have filed the IO. Always. Always. May I appeal lordship? 27 minute petitioner in custody minute since 24/5/2025, 79 years old minute. 24/5/2025, 79 years old minute. And petitioner may be released on bail, my lord. Finally, my lord, the matter may be decided after it's an end of the year, my lord. Petitioner is a indigenous Muslim community, my lord. Yes, my lord, as per my lord, statement, my lord, instruction, my lord. And Aadhaar card is here, my lord. Aadhaar card page 44. Voter card also page 43. Page 43 voter card issued on 2013, 67 years. And there is, as per Aadhaar card, my lord, his date of birth 1946. This is the voter list, my lord. Normally in the voter list, my lord, correct is not mentioned. My voter is mistake, my lord. Till now. This is the fact. My lord. No, my lord. Every year, my lord, BLO is our neighbor. He has corrected my yes. But subsequently, I have seen the voter list. And last occasion, my lord, my voter card. He's a lucky person. Milord. Aadhaar card page 44. And voter card is page 43.
Yes, 79 years, my lord, and it is, my lord, the only question is, my lord, it is not an expertise where, my lord, he was not, no notice was served. Yet. But, he, my lord, there are 6, my lord, he said, my lord, he received notice. Yes. That is the only consideration, my lord. Otherwise.
You framed a preliminary issue of maintainability. What do you say on that?
My lord,
On maintainability, what you have to say, because you have not even issued notice in this matter. What's the explanation here for the delay?
a delay, my lord. Of para 10, my lord.
this can't be a good explanation for 13.5 years.
Yes, 70. Jomirali is the brother. No, my lord, here is my lord only voter list of 1956. No, no.
The specific question is, any voter list of Jamir Ali with your father? No.
No.
Any other document of Jamir Ali with your father? No.
My lord, one order, my lord, here in space, 45, my lord. Jomirali declared India. Address is same, my lord, Borpatha. Place 45. A petitioner, one of the sister also declared India. Place 48.
It examine and passport. Remember?
Zomir and his mother name appear in the voter list of 77.
1970, just to.
Mother name is Nisha Khatun and Zomiruddin name is
Page number?
a voter list of 1977, page 30.
Only one point, my lord. As your lordship has seen para 10, my lord. This may be, as your lordship has seen para 10, my lord, this may be read with para 6 also. Because the conduct will come. Para 6 prior to my lord filing, passing of the opinion. Also, yes. That is, my lord, para 10 is after passing of the opinion. Para 6 is prior to passing of the opinion, my lord. The proceeding is started and writ petition. Page 8. Para 6, man. Proceed, yes, madam. No, no. But initially petitioner absent subsequently appeared on 24/9/2009 and 31/10/2009. Took time to file written statement and subsequently dates he has absent without filing petition. Due to absent tribunal pass expert order after 2009 up to 2012 with it, my lord. There is no explanation. Then after filing of this, passing of this opinion on 19/6/2012, writ petition is filed. Only my lord, when he is detained. That is in para 10, man. Next part is in para 10. When my lord, on merit also, documents also. If I'm surprised, he has no voter list of any kind of prior to 671, my lord. All documents, even we, my lord, ignore the discrepancies of age. Somehow his name would come in the voter list prior to 1971, my lord. Because if we accept, my lord, the documents, because this may not be appreciated, however, my lord, if we see first voter list of the petitioner,
1956.
yes, page 32, my lord. As per this document, he is 60 years in 1985. So if he was 85, yes, but those, my lord, just I'm showing, my lord, that because even then also, he would be, my lord, elder than his mother. If this is accepted, his date of birth is sometime in 1925, and on the basis of 1965 voter list, the mother's date of birth will be sometime in 1929. The 4 years elder than the mother. So this discrepancies are very huge numbers. And even though we accept, my lord, then next the date of birth projected by him 1946 as per the, my lord, the voter ID and, my lord, the Aadhaar. Then also he would have been voter prior to 1971. 1965 he is, my lord, 21 years. Those things are also there, but those are not, I'm not on merit because those are not, my lord, only on the issuance of notice, maintainability part.
Timing item 30.
Yes, 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 yes. That's it.
Is that letter- 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 Release could work, huh? Release could be like.
May spill lordship. But in this case is some different lordship. Lordship, petitioner was declared for arrest by the Jorhat FT in 2017. Therefore, prisoner again challenged the order and approved honorable court. High Court also dismissed the petition lordship. Therefore, again challenge this order and it go he has gone before the honorable Supreme Court and the Supreme Court also dismissed his petition. Then under that some this petitioner was taken into custody.
The issue which you have raised, you have already answered on in various cases. You better take one of the orders from Mr.
In fact,
And
in this
Be
case,
prepared with, and then you make your submissions. But this is an issue we have already decided.
look, decide.
The
I,
issue is that once he is declared to be a foreigner, and that order is attained finality, we have gone to the extent of saying that the order of bail granted by this court would not come in the way of taking the person into custody for the purpose of deportation, for the purpose of expulsion. You can have this, one of the orders from him, be prepared, we'll take it up tomorrow.
during COVID period, Lordship, they released us. My lord,
You-
during COVID period, they released us.
We understand, but that we have answered by saying that even if he had been granted bail, does not prevent the state from taking him to custody for the purpose of expulsion. We have gone to the extent of saying to that extent.
In this
Take the order from him, you be prepared and then make your submissions. Because this will be otherwise rejected.
his petitioner also, his father also approved before this. Responsible about to pass.
Hmm?
This is Secretary of Human and Political Department. His father approached and filed a representation. It was annexed.
Where is that?
Page 34.
Page?
Page 34. It was filed in 29 October 2025.
Can you find it out what has happened?
My lord,
How have you sent this representation?
his father,
Is it page 34? How you
Yes.
have sent it? There's no receipt seal of the office, that's why we're
It
asking.
was received by the respondent party.
Huh?
It was received by the office of respondent.
Which page?
The first copy, receipt copy. Receipt.
3/11/25. Can you call your clients and get instructions as to which place this was sent so that Mr. Pang can find it out? You can go out, have a talk with your clients and who have instructed you and then tell us this receipt is by whom? Which office, where did he go and give delivered this? You can ask, we'll take it up after some time. You can go and call your clients and then take instructions. This has been given to whom? Otherwise, Mr. Pang will not be able to get us instructions.
In fact, I have not been served copy also in this case.
Huh?
I have not been served copy also in it.
Oh,
Yes, I am giving worship. We will wait for some time.
just tell him, give a copy and give it the date. We'll get it in some time. Which office it was delivered, just tell us. Lemon, in a simple language, he can tell you, this Home and Political Department may have some subsections. Because this matter is being dealt with the Home and Political Border Department. And there's otherwise a Home Department which goes to the other administration. That is Police Administration it goes. So this application is where? That is number one. Second is that under no law, the Secretary of the Government of Assam is empowered to grant bail. He does not even have the authority to suspend the opinion of the tribunals. So therefore, no practical purpose is served to give a representation to the Home and Political Secretary to say that please grant me bail or give me any relief after I have been declared a foreign national. The only way is that the authority we can take a decision to enroll him as a citizen, register him as a citizen. That's the only thing which can happen. That also is, you can say by judicial interpretation is almost a bar, because once a person has been declared to be a foreigner, then he can't be under the explanation given in the judgment of 6 AA. He can't be accepted as an Indian after that. So in all these counts you fail. You're just trying to get information for you if something has happened. But we must tell us where this representation was ultimately given. You see, the reason is we can't give a direction to the authorities to dispose of the representation. He can dispose of a representation only when he has powers. And we know very well that he does not have power to grant bail or to suspend the operation of the impugned opinion. So this representation actually doesn't help us, in fact, for the purpose of judicial decision making. But still, since you are there, we just wanted to find out whether something has happened to that or not. Only that much. We'll get him, we'll take it up after some time. 3:30 we are here. Yeah. Yeah.
Upgraded item 35.
Two more I will take.
Which has the representative? It's matter from the player made by legal counsel for the petitioner, list on 19. Yes.
May I please ask you? My lord, the IA for amendment of cost title, my lord. And my lord. Further granting changes on. But I have stated, my lord, okay, it's paragraph number 3, page 6, my lord.
Page 6.
Yes, my lord, paragraph 3, 4, and 5, my lord, I have stated, my lord. The address, name and address in the referral case, my lord. Petition are not mentioned in the writ petition, my lord. He has filed this petition in the original name, my lord.
You appear not being able to follow paragraph 3.
My lord. Paragraph 5, my lord, the address to be amended, my lord. Paragraph number 5.
Petitioner. Yes, Mr. Payang.
The lordships have already granted bail, my lord, to the petitioner, but this
This
is
address-
bona fide mistake, my lord.
It
It-
for the letter.
Hmm. What will he put the context for an original loan to the future? The allow has expectation I can also context.
This is something very difficult because she herself identified herself Kurseda Bibi man, Kurseda Khatun. Now she want to change the name, my lord,
Not sense, my lord.
because in the reference it was Khuteja Bibi.
Khudeja Bibi, only in the reference, my lord, but petitioner contested as his, her, my lord, original name, correct name, Khudeja,
Kurseda Bibi.
Khursheda Bibi and Khursheda, Elias Khursheda. Only in the opinion. That is.
You can do it.
My lord, yes, my lord, that at this is the name may be corrected, no issue on that,
Yes,
my lord.
yes,
But
yes.
that may not affect the, my lord,
Yes.
merit of the case.
Yes, my lord, yes,
That mustn't.
yes, my lord.
No, but that can't be done.
Yes, my lord.
What you are saying can't be done. Once you amend it, consequences of amendment will follow.
Yeah.
We can't say that the writ petition is amended, but the effect will not follow.
Okay.
And my lord, because otherwise, my lord, because my lord, the inside, the evidence, what is there, this has to be seen, my.
No, in
that
evidence
case.
in everywhere, my lord, there is
Because, my lord, the reference is Khuteja Begum.
Khudeja Bibi. That is wrong
She
reference.
contested herself as Kurseda Bibi. And alias Kurseda Khatun man.
In the tribunal, before the tribunal, the petitioner my lord, contested by her original name, not Khudeja Bibi. Only my lord, in the opinion heading part, my lord, Khudeja Bibi. In the even my lord, in the
Just a moment.
my lord, in the opinion also, my lord, her correct name is there. In a
It's okay, we'll see when it comes. We amend the allow is the amendment is
Yes.
not getting bail.
my lord, I also prayed Yes, my lord. My lord. Already.
I have,
But even my lord, in the repetition paragraph number 5, I grabbed the leave before you lost it to contest the case by her correct name. Yes, my lord. Well, further, my lord, 10 days time may be granted, my lord, to my lord. Under paragraph 5, my lord.
Title. Preparing a amended cost title for the AOJ FT section by 19/12/2026. So that the amended cost title can be incorporated in the rate petition with suitable corrections to the database of the court. Next paragraph. In this time from the date of the order is granted to the applicant to take bail in terms of the order dated 25/9/2025 passed in WBC 5664 of 2025. Next paragraph. This order shall be read together with said order dated 25/9/2025 passed in WBC 5664 of 2025. Next paragraph. Even the petitioner appears within the extended time, the Superintendent of Police within record order for Dhubri shall do the needful in terms of the hearing before referred order dated 25/9/2025. So next, but this improvement application stands disposed of.
Your Lordship.
Upgraded item 32 for admission.
My pleasure, your lordship. In this case, we have filed an IA for bail, lordship.
Which page is the opinion?
Opinion will find, your lordship will find at page number 62.
52,
62.
60,
Ex parte order, lordship.
25. Mr. Pai? 2025 opinion.
2020.
Parties.
Yes, madam, 2025 opinion. But despite of receiving notice, he never appeared, ma'am. From 21 to 2024.
What is your explanation for not being able to appear before the?
My lord, I have explained that, my lord, before that lordship, one opinion is their lordship, in that lordship person interim order. This person took him to Kerala lordship. He is smarter than this person lordship. We have explained in paragraph number 6, 6
number?
to, paragraph number 6, 7, 8 and 9 lordship. And your lordship order is there. Because same address, same day, they are residing in same area, same place, lordship. This person took along with this person. Later on, we came to know, lordship, that is why we could not bring it in the record, lordship. This same address, same day, this opinion was passed, lordship.
No, we are not being able to follow. Please explain again.
My lord, this present petitioner and the other one which I placed, their friend lordship. This person, we have explained our delay that they went to Kerala lordship. So for their work lordship, that is explained in from para 6 to 9 lordship. On last occasion also I have explained lordship. This along with this person lordship, he went there lordship. That is why lordship, they could not contact the Angus Council lordship in that proceeding also and this proceeding. They're distant in relation lordship.
In Kerala, you don't have mobile towers.
No, my lord, with this is this is not that smart person lordship. And that one was smarter than that is why he could not arrest by the authorities. That is that.
No, we are not on that.
Lordship.
But, if for 1.5 years you don't come, and it is very hard to believe.
Well, I engage the council lordship. That is, I'm not on merit right now, but otherwise I have all documents lordship.
No, but you have to explain why you did not appear before the.
I explained lordship in my paragraph number 6, 7, 8 and 9 lordship. 6, 7, 8 and 9 lordship. I engage.
See, you say so many things.
My lord.
But you don't say only one sentence which we require everywhere.
My lord,
You have not said here that you paid fees and then went away.
I
To your
paid-
advocates.
Well, I paid to, I engage
But that
council
is not
lordship.
here. Why would an advocate, you see, we are yet to find a lawyer who would not appear, who would appear without fees.
Paying. Minimum fee you have paid.
Minimum, I'm ordinary person, my lord. Minimum fee I pay, it is reflected in the steps taken by the petitioner.
When we are not looking, you speak to Mr. Uddin. With minimum pay, whether he will sit here for this long. Don't ask him in our presence. When we are not there, ask him.
Well, he arrested on 7/7/2025, laws, more than 5 months, laws.
Okay. It's a time we are giving. Wait.
But I have to get the instruction because he in detention, my lord.
Detention, he is in detention.
He is in detention, my lord.
Detention. Yes,
Because, let me get the instruction, my lord, because at this stage I cannot see. Because the process of deportation said, my lord.
he is in detention, laws.
Yeah, then I-
Ase. Ase. Yeah, yeah. As, as me, I go away.
Just add that word, it is not yet been deported. Huh? But as Nargis now counsel for the applicant, SK Nargis now counsel for the applicant, and so for the respondents. Next one. By filing this interlocutory application, the applicant who is the petitioner in the connected WBC 5255 of 2025, and is stated to have been taken into custody on 7/7/20 pursuant to ex parte opinion dated 22/4/2025. Opinion is at which page?
62, laws.
62. What did thereby ex parte opinion, thereby declaring him to be a foreigner post 25 in 1970 is praying for bail. And for being released from detention. It has been submitted that the currently lodged at where?
Gwalpara detention camp, laws.
Temporary jail. Not here, Golpa.
Gwalpara, laws. Detention camp at Gwalpara, laws. In I have mentioned, laws, in paragraph number 1.
7/7/2025. Next part. The Joint Standing Council for the FT matters has proposed the prayer for bail. The ground that the applicant is a declared foreign actor. Next, considering the projection made in the connected petition. And taking into consideration that the applicant is under detention since is in custody since 7/7/2025. Court is inclined to release the applicant, namely so and so on bail on the following. Don't pay. Subject to that in the event he has not been deported out of the country, he shall be released on bail on furnishing a bail bond of rupees 5,000 with one surety of like amount to the satisfaction of those three conditions. The condition of bail from the applicant is not to leave the jurisdiction of the Superintendent of Police Border Morigaon without advance intimation to the said authority, written intimation to the said authority. Even the petitioner leaves the jurisdiction, it would be open to the said authority to take the petitioner into custody without Any further authors of report? This application stand. The two conditions we have imposed, not to leave jurisdiction. If you leave, then will be allotted to take you into custody again.
Keep clear.
Upgraded item 18 for admission.
Made to the lordship. Lordship, in the light of this honorable court direction, my lord, on 24th September, I have been directed to furnish a copy to the Deputy Commissioner, Police B. I have submitted the certified copy of this order, my lord. Yeah. Okay.
Yes, what is the explanation of yours for the 6 years?
My lord, at paragraph 17 and 18, my lord, at page 20 and 20A, my lord. Yes. My lord. My lord. Notice, my lord, regarding the arrest. No. Here, my lord, I am been declared, my lord, foreigner, my lord, that petitioner is able to establish his linkage with his parents, my lord. But his parents' linkage with grandparents, this is on that question, my lord, on doubt. I'm my lord, Lordship absolutely right, my lord, in this regard, my lord. If Lordship allow me, my lord, since 2019, he's a declared foreigner, my lord. He has no land on this, my lord. And so 2025, suddenly that person is come and said that this is that. And my lord, in my support, my lord, Lordship, since I leave it to option Lordship before that, my lord, I have to place two citations of the apex court, my lord. And thereafter, Lordship may, whatever Lordship decisions, my lord, I will, my lord. And my lord, I like to first rely, my lord. Air 1987 Supreme Court 1353, that is Collector of Land Acquisition, that is case, my lord. Certain principle laid down on regarding the consideration or is it non-consideration of delay, my lord, at paragraph 3 only, my lord. Certain principle laid down, my lord. Whether this taking advantage by the applicant or not, this is the ground involved, my lord. Shiva. Lastly, my lord, is the daily wage under, my lord, layman method. In this ground, my lord, if, 1981, that is Rafiq and another death, also discussed, my lord. So far as villagers or laymen is concerned, my lord, if they don't have any knowledge, my lord, on that ground, my lord, condone, my lord. Paragraph 3, here also, my lord. Six. That's shit. For 6 years, my lord, and my lord, that other person, even that person is still roaming outside, he's not arrested, my lord, the appellant is outside, my lord, not, he's. And Definitely, my lord, it is true, my lord, your lordship very correct, my lord, 6 years it is delayed, very serious, my lord. No, my lord, in the tribunal, my lord, my case is, no, it is established, I established my linkage with my parents, my lord, that is on get on merit, my lord. I am able to establish, since there is no case against my parents, my lord. Though I am established to able, that my parents, the citizen of India, my lord. But parents, that is on ground, on your doubt, my lord, rejected, my lord. So my own, my lord, it's a question of, my lord, my citizen, on that only delay ground, my lord, I will be deported without on a foreign land, my lord. It is the only ground. But on merit, my lord, I am able to establish my linkage with the parents, my lord.
My lord, read petition, my lord, the dealing lapses. May not be, but my lord, the lapses on the part of the petitioner, that has to be seen, and that explanation has to be done properly. We are not saying, my lord, that the delay, if it is properly explained, if it can be, my lord, accepted as a proper explanation, it may not be, my lord, considered. However, my lord, this explanation, my lord, the not tenable in the eye of law, because, my lord, it is his petition, it is said that petitioner got complete details from his engaged counsel. It is his duty to, my lord, to trust with the petition counsel, and counsel's name is not disclosed. And there is no, my lord, little limit. I. I thought. No, that is true, man. Listen, Norman. Understood. Even I know the, my lord, the situation, but even, my lord, in the even in light. My lord. Actually, it's the matter. I was thinking about. I hope that the business people. Yeah. Even I'm, I say, my lord, I think a point on particularly on this. It's very detailed for item. My colleague died. What is difference between I thought?
My lord, no, no, no.
The appeal is returned for being filed before the district judge Jorhat. If the appeal is presented within outer limit of 3 weeks from the date of the order, cover the time spent in this court from 18/11/2025 till presentation of appeal within outer limit of 3 weeks shall be treated as time bona fide stand before this court for the purpose of section 14 of the Limitation Act.